Hello, everyone. And today, the title of our seminar is an update on child protection legislation and guidance. Now, this year has been a particularly productive year. So in this seminar, we're going to be looking at two main statutes, the Crime and Policing Bill and the Children Wellbeing Bill, both of which signal developments for child protection. So anyway, without further ado, um, let's have a look at the first slide. Thanks very much, Shamika. So that's the Children's Wellbeing and Schools Bill and the Crime and Policing Bill, but we'll also be looking at other developments and updates in the child protection field. Okay, could I have the next slide, please? So the Crime and Policing Bill. So this was introduced back in February. It's in its second reading of the House of Lords. We can't be sure when it will actually come into law, and it may take until next year. But anyway, what it does is it introduces some new offences, including something called cuckooing, which we'll be looking at later. And there's also new offences that relate to child protection, and we'll also be looking at the new mandatory rules, new mandatory reporting rules. Next slide, please, Amika. So first of all, what we've got is a new criminal offence of child criminal exploitation. So section 40 of the bill creates this new standalone offence. So in a lot of these child exploitation cases, what you get is people being prosecuted for crimes which come under the usual statutes, such as the Sexual Offences Act 2003. But what the Crime and Policing Bill is, it introduces a standalone offence for the offence of exploiting children. It says if a person engages in conduct towards or respective child with the intention of causing the child to engage in criminal conduct, so it doesn't just have to be sexual, it can be physical and emotional as well, they will commit a crime. And a sentence in the Crown Court can be up to 10 years. Can I see the next slide, please? What the bill also does is it introduces child criminal exploitation prevention orders. Now, in previous seminars, we've looked at the whole raft of measures that are available to the police and local authorities to tackle child exploitation. So there are, in fact, a whole lot of powers which seek to disrupt the activity of child exploitation. What the Crime and Policing Act does is it introduces a new set of measures which are known as child criminal exploitation prevention orders. And very briefly, I mean, this can be aimed at anybody who's exploiting a child. You don't need a conviction in a magistrate's court or a Crown Court to do it. You can simply take it out if it's felt that that person is a risk to children. I mean, obviously, there are various safeguards on it, but it gives another string to the bow of the police when they're tackling this rather difficult crime. Next slide, please. Cuckooing. Now, cuckooing is where criminals move into someone's house. It's generally going to be somebody who's vulnerable. So they might be mentally vulnerable or physically vulnerable in some way. And what they do is they use their house or their flat, whatever it is, to store weapons, drugs, sometimes grow drugs. Effectively, it is a way of having property being used for the purposes of crime. And it's actually quite common. What cuckooing does is it sets up an offence where a person commits that offence if they exercise control over the dwelling of another person. They do so for the purposes of enabling the dwelling to be used in connection with the commission by any person of one or more relevant offences. So that's cuckooing. Next slide, please. So there's other new crimes and sentencing powers created by the Crime and Policing Act. Causing internal concealment of item of criminal purpose. So what some criminals do with children is they get them to hide within their internal bodily cavities. I mean, this is a revolting crime. They'll get them to hide drugs. Sometimes it's even weapons, but it's any item that's used for criminal purposes. Now, obviously, this can be very dangerous indeed, but Effectively, this is a new offence that says, well, if this is what you're forcing a child to do, that is going to be a crime on its own. We also have legislation in relation to something called child sexual abuse image generators. Now, what are these? What these are computer programs, and they can convert the image of a child into an abusive image, child sexual abuse, child abuse imagery, essentially. That's what they do. Now, what the Act does is it makes it an offence, for anybody who tries to produce one of these programs. Apparently, there was a gap in the law. So that's image generators. The next one is online facilitation of child sexual exploitation and abuse. So if you're running a forum and that forum's being used by abusers, either to groom children, to talk about the abuse of children, share information, images, whatever it might be, if you're facilitating that online forum, you are committing an offence. Again, that is designed to close an existing gap in the law. We've also got increasing sentences for sexual grooming of children. So at the moment, if you want to sentence somebody who's involved in child exploitation, you use something called the sentencing guidelines. So what the sentencing guidelines do is they set out a number of factors that you have to take into account as to how much, for instance, prison time somebody's going to be awarded. Now, what the bill says is that these grooming offences, basically, if you're caught in child sexual exploitation, that in itself will make your sentence higher. So that's what's known as an aggravated factor. So if, say, you commit a crime and that crime is as part of child sexual exploitation or child exploitation, sorry, it is child sexual exploitation, what it means is that you will get a higher sentence. Could we have the next slide, please? Now, the next one that we're going to be looking at is mandatory reporting. So mandatory reporting is where if you see a sexual crime taking place against a child, you have to report it to the authorities. That's effectively what mandatory reporting means. Now, there are already duties in documents such as working together on people like teachers and social workers that they have to report. What this new duty does is it says, well, this is a new duty and you have to report. Now, the bad news is that unfortunately there is no criminal sanction. So in other countries, such as the United States, certain states in the United States, if you don't report, they send you to prison. In some European countries, it's either prison or it's a fine. So there's a criminal sanction. In this country, we veered well away from that. So the only sanction that you'll get is possibly to be disciplined by your professional body. So if you're a social worker in England, it'll be Social Work England. If you're a teacher, it'll be the professional body for teachers. But what essentially it means is that this is a duty. Anyway, what does it cover? Well, it catches those people who carry out a relevant activity. Now, a relevant activity can be one of two things. It can be a regulated activity. So we've got something called the Safeguarding Vulnerable Groups Act 2006. And what that does is it creates a list of people who are involved in regulated activity. Now, you cannot undertake regulated activity without undergoing a check. And that means a check of your criminal record, but also other databases for misconduct and things like that. So that's regulated activity. And typically it catches people who are social workers and teachers. Anyone working with children in a supervisory category will probably be undertaking some kind of regulated activity. So they're caught by this new duty, but there's another type as well. Now, these are people who are carrying out a relevant activity, and it's described in the Act. It's actually in Part 2, Schedule 8 of the Draft Crime and Policing Act. And these are people who are not normally described as undertaking regulated activity, but they're either looking after a child on an individual basis or they have regular unsupervised contact with their child. So there's a whole list of people who are going to be involved. Could we have the next slide, please? We can see the list of people. It's career advisors, local authority employment advisors, anyone looking after a child who has a Section 20 accommodation agreement. It'll be anyone providing suitable accommodation for care leavers aged 16 or 17. Could be a child's personal advisor, anyone with whom a child is placed by a voluntary organisation, that'll be a charity. It'll be anyone looking after a child by virtue of a care order, supervision order, education. So this isn't necessarily people who are professionals. These are just sort of ordinary people who look after children. And a court officer appointed by the court, prison or probation officers, and religious teachers as well. So quite a wide list there of people who wouldn't normally be involved in what we call regulated activity. So they are all caught by this new duty. Could we have the next slide, please? So what is the extent of the duty? Well, what the legislation says is that if you're a person covered by the draft bill, you must make a report as soon as practicable if you're given reason to suspect that a child sex offence may have been committed at any time. And as soon as practicable is as soon as possible. I mean, there is a 7-day period during which you don't have to report if you're concerned about the child's welfare, but by and large, you have to do it as soon as possible. Next slide, please. Now, there isn't actually any sort of statutory means by which you do report. You either do it orally or in writing. You do it to either the police or the local authority. But what the government says is that they are going to introduce regulations as to precisely how a report has to be made. That will take some time, which is why I think this part of the Act won't come into force this year. I think it won't come into force until next year. Anyway, you make the report. In what circumstances do you make that report? Well, what the Act says is that there has to be a reason to suspect. And if you look at the slides, there are 5 instances where you have reason to suspect that something has happened. So you witness conduct, which is a child sex offence. Child tells you something which would cause a reasonable person to suspect that it's taken place. You're told by the perpetrator, basically, something that causes you to suspect that an offence has taken place. And you may see an image or hear an audio recording, and a reasonable person would think, well, actually, that is a child sex offence. So a number of conditions there. How that actually works out in practice will remain to be seen, because, of course, we won't know whether this is acting or whether this is working, this mandatory reporting, until people start being hauled up before their professional associations, at which point all of this will become extremely relevant. Because there's no criminal sanction, it's going to be very difficult to know whether this is actually working or not. Anyway, let's have the next slide. Now, there are exceptions. So you're not required to report in certain exceptions. Now, to be brief about this, in the notes and in the slides, we set out what the exceptions are. But the exceptions are generally designed to exempt things that happen between children who are aged 13 to 18. And the reason for that is relatively obvious, is that all kinds of sexual activity goes on between 13 to 18-year-olds. And what the Act is saying is that we can't report everything if it is consensual. Now, you might say, well, how can a 13 to an 18-year-old consent? But essentially, what the exception means is that if you reasonably believe that each person involved in the suspected offence was a person aged 13 or over, and where the suspected offence was in offence to a certain number of offences which are covered, basically, and you're satisfied that each person consented to the conduct, and you're also satisfied it wouldn't be appropriate to make a notification having regard to the risk of harm to the children involved, then you don't have to. Now, there's effectively a defence. So let's say a teacher sees a text on a child's mobile phone and it's of an image And that is something that they would normally have to report. But if it was sent between two children aged 13 to 15 and they can satisfy, well, it'll be their professional association, that it wouldn't be appropriate to report that there was an element of consent there, then they don't have to report at all. So that is essentially how the exception works. Next slide, please. As I've said, there's if you fail to report, it's not a crime. The only sanction comes from your professional association, which could be serious. I mean, you could even be struck off. There is a crime of preventing or deterring someone from reporting, so that could end you up in front of a criminal court. But obviously, that's something that you would need to do deliberately. Anyway, let's move on from there to the next slide, please. Removal of limitation for child sexual abuse. Now, very briefly, at the moment, if you are a victim of child sexual abuse and you want to bring a civil claim, a compensation claim against your abuser or against the person who employed your abuser or against a person who let it happen, then you have until your 21st birthday in nearly all circumstances. You've got until your 21st birthday to issue court proceedings. If you don't, you are outside of limitation. Now, the court can, in some circumstances, let you through, but it's very difficult indeed. So essentially, as the law stands at the moment, you need to bring your claim through the courts, issue your claim before you are 21. Now, unsurprisingly, an awful lot of people miss this time limit. Now, what this new clause in the Crime and Policing Act says is it says, well, if you miss that date, we're going to disapply it. We're going to disapply that date. So there is actually no time limit. So if this is something that's happened to you back in the 1970s or the 1980s, the defendant can't say to you, well, you're over the age of 21, you've missed the 3-year time limit. So what the new law will do is it gets rid of that 3-year time limit. Now, the defendant, however, is allowed 2 defenses. The Act itself, the amendment, is retrospective, so it will apply to things that happened back in the 70s, 80s, 90s, etc., etc. But if that is the case, the defendant gets 2 defenses. And defense number 1 is, I can't have a fair trial. This claim is brought against me. It's too long ago. I can't find evidence. I can't find witnesses. They've all gone. I can't have a fair trial of these issues. That's the first defense. The second defense is that there is the issue of prejudice between the parties. So the court will look at the issue of who is prejudiced on either side. It's not quite clear how that test would work, but the important point is going to be fair trial. Because under the current law, if you're over 21 and you bring a claim, so you're out of time, what happens is that the court applies a test, which includes the test of can we have a fair trial. Now, what this means is that the new law won't really change the existing law by much, because even though there isn't this 3-year time bar, the fact of the matter is that you're still met with this defense of not being able to have a fair trial. So it's not quite clear what difference there will be. Anyway, that is the amendment to limitation. If I could have the next slide, please. So on this slide, we set out the actual defences which are available. I mean, Scotland has had this law for some time now, and we do have some case law from Scottish courts, which gives us some idea of how Scottish courts have applied it. And I think that English courts will apply it in the same way. Could I have the next slide? So if you're an advocate and you're acting for a child, the question is, what should you do? Well, this is my advice. If you're going to make a compensation claim, if you're dealing with a child or a young person, the advice must be that they should make the claim. They should consult a solicitor, somebody who's experienced in this type of work. They should do so by their 21st birthday. That's the most important one, or they should do so as soon as possible. This is really important. You shouldn't wait around. Because if you wait around up until your 21st birthday, basically, generally by that time, it may be too late. So that's the first thing. You should consult a solicitor as soon as possible and get some advice. If you miss the 3-year time limit, i.e., you come forward after the age of 21, the time limit can't be used against you, but the defendant has this defense, which is we can't have a fair trial. It's too long ago, basically. Be aware that there are other types of claim which are not affected by this amendment to the law. So human rights claims will still come under a 1-year time limit, which runs from the date of the human rights breach. Now, it can be extended, but it's a very tight time limit, and it doesn't take any account for whether you're disabled or whether you're a child. It's 1 year from the breach. If you're making a complaint, a statutory complaint, that is 1 year from the date of the maladministration, otherwise the thing that went wrong. And there's also claims to the Criminal Injuries Compensation Authority, which again, they remain 2 years from the date of the incident. But in some cases, if you're a child, you can say, well, it's 2 years from my 18th birthday. That's really beyond the scope of this lecture. You would need to consult a solicitor in relation to these rather tricky time limits because they operate in different ways. Anyway, let's have the next slide, please. So there's other features in the Crime and Policing Bill. So the other one that we've got is that the government will issue statutory guidance in relation to something called Sarah's Law. Now, what's Sarah's Law? There's something called the Child Sex Offender Disclosure Scheme. And what it does is that if you come into contact with somebody who you believe is a danger to a child, so let's say you're a single mother and it's somebody who you meet on a dating website, and you are concerned about that person's history and you think that they might be a threat to your child, you are allowed to go to the police and you can say, well, I want information about this person. I want to check them out. Now, that's known as Sarah's Law, and there is a scheme. Now, what the Crime and Policing Bill does is it converts that scheme into what we call a statutory scheme, which means that it has the force of the law. You have to follow whatever is in that scheme. So we've got the same scheme, but it's just it will be beefed up in terms of legality. There's also new restrictions for sex offenders changing their name. A sex offender can change their name. There's nothing that the law can do to stop them from doing that. But these new restrictions mean that if they do so, first of all, they have to inform the police, but also the change in name can be held up. It actually needs to be approved in certain circumstances. So that is designed to counteract the possibility that a convicted abuser tries to change their name and then with a new name tries to get close to children again. Section 102 introduces a new offence of encouraging or assisting serious self-harm. So that's aimed at websites that promote suicide. And there's also new laws in relation to regulated activity. Now, we looked at that on mandatory reporting. So regulated activity covers people who work with children on a professional basis, and they have to undergo police checks. So the law covers people who are teachers, social workers, etc., but it doesn't actually cover at present people who they supervise. Now, what happened is that they brought in the Safeguarding Vulnerable Groups Act 2006, and then the Conservative government of David Cameron decided to have a bonfire of all the red tape, and they got rid of the requirement for supervised people to be police checked. And what that meant is that as long as these people were supervised by somebody senior, it would mean that they wouldn't have to go through a full check. What the Crime and Policing Bill does is remove that. So no, everybody now has to be checked, everybody, whether they're supervised or not. So that's that particular change. So could I have the next slide, please? let's look at the Children's Wellbeing and Schools Bill and the key features. Well, I'll rattle through these quickly, but basically what we've got, and again, this bill is in the House of Lords, which means it might become law this year, but probably next year. We'll see. So what the bill is doing is it introduces something. It introduces something called family group decision making, which is designed to include more families or the rights of families. So when a decision is made whether to take a child into care, it beefs up the rights of the parents of those child so that they can be involved. And the idea behind it is to get family, not just immediate family, but all the child's whole family involved, so that they may be in a position to take that child into care rather than relying on the state to do it. Okay. Another thing that is included is inclusion of childcare and agencies in safeguarding arrangements. So in each local authority, there's what we call multi-agency arrangements, where the police and the NHS and the local authority sit down together and they say, well, how are we going to protect children in this area? And what the new bill does is it includes childcare and education agencies. So I think one of the problems with child exploitation cases is that schools weren't necessarily involved in those arrangements. So now they are under this new bill. That's the whole idea behind it. There's going to be a new type of multi-agency child protection team for local authority areas. So we have these arrangements already, but what this bill does is it creates this new type of team, which is a multi-agency child protection team. And on that team, you've got to have somebody from education, social services, health and police. And what they will do is they will deliver child protection activities. It's all about these different agencies basically working together. Okay, next slide, please. Now, another change is something called kinship. Now, kinship is a word that describes what happens if parents can't look after a child, and so they reach out to a relative. It doesn't have to be a relative; it can be a friend, and they say, "Well, could you look after this child?" So it's like an informal arrangement. It's not something that is overseen by the local authority, but these people come along and they look after the child. Now, the local authority may become involved and they may say to that kinship carer, we'd like you to be a foster carer, we'd like you, to be a special guardianship or something like that. But this is something that affects an awful lot of children. And what the authorities are trying to do, or what the bill is trying to do, is to bring this within the scope of the Children Act so that these people who are looking after children know what their rights are. So what the bill says is that there has to be a local offer requirement, which means that you have a local offer already for what we call care leavers. So care leavers are entitled to know what kind of support they can get from a local authority. Well, this is exactly the same. It's the kind of support that people who are kinship carers can get from a local authority. Because, of course, what's being said is that these people simply look after these children. They have absolutely no support whatsoever from the local authority. And, of course, it's a very expensive business for them. So this is designed to close that gap so that they can get support. And there is a new Section 22I of the Children Act 1989, which will have a legal definition of kinship. Okay, next slide, please. And we can see on the slides, there's a kinship local offer requirement, basically. So that will introduce a statutory strategic duty on local authorities to promote the educational achievement of children with a social worker and child in kinship care. There's also something that introduces called staying close. Now, staying close is designed at care leavers. So typically when care leavers leave care and they go out into the big wide world, they may be care leavers and they may have support, but the problem is an awful lot of them, too many, become homeless. And the reason why they become homeless is because they can't find accommodation, or they find it very difficult to find accommodation, which means that they're sleeping on the streets, whatever it might be. Now, what staying close does is it simply says that the local authority has to provide staying close support to care leavers, which is designed specifically to deal with, specifically designed to deal with their rights of accommodation. So it's designed to stop them from becoming homeless. We've also got a local offer for care leavers. Now, there already is a local offer for care leavers, but this new local offer, well, it's an amended local offer, beefs that up. So it requires local authorities to publish the arrangements they have in place for the purposes of supporting assisting care leavers in their transition to adult and independent living. Okay, could we have the next slide, please? There's a new law in place which is designed to help care leavers into accommodation. So if you're a care leaver, you are a priority. You're in a priority on the housing list, together with other people as well. And that's recognized by the law. But the problem is that care leavers are still having difficulty. Now, one of the things that happens is that the care leaver will go along to the local authority and say, look, I'm homeless, I need somewhere to go. And the local authority will say to them, well, I'm awfully sorry, but it would appear that you've become intentionally homeless. So they were in accommodation, but they left it intentionally. And that's a situation where a local authority might say, well, you may be a priority, but you've done this intentionally. We don't have to house you. Now, that is all swept away because the Children's Schools and Wellbeing Act, it amends the Housing Act. And what it means is that if you're a care leaver, you can't be found to have made yourself homeless intentionally. So that's an important thing for care leavers. Accommodation of looked after children, regional cooperation agreements. Now, at the moment, it's extremely expensive to accommodate children. So if you're a child in a private children's home, I mean, typically the bill rocks in at about $250,000 a year, if not more. And for some years, local authorities have been trying to do something about this because the cost is just so prohibitive. Now, a number of reasons why the cost is so high. It's not necessarily the case that it's profiteering care companies, actually quite the reverse. The problem is that the sector is run privately because local authorities years ago decided that they would run care homes. But the trouble is that for various reasons, these placements are extremely expensive. Now, what the government is doing is it's saying to local authorities, right, you local authorities within a region have got to get together. And when you purchase care, and it's not just private children's homes, it's also foster care, but any kind of purchase of care from the private sector, you've got to do it together. And the idea is to bring the cost down. Now, whether this actually works or not is another matter entirely, but it's an idea that's been in the system for some time. And there are actually 2 pilot regional cooperating care arrangements. And the idea, again, is to bring the cost of private care down. Could we have the next slide, please? Now, another key feature of this bill is the creation of new children's accommodation with deprivation of liberty. So deprivation of liberty means locking children up. Now, you can send children to a young offenders institution. You can send them to a secure training center. There's only one of those left. You can also put them in secure accommodation, or they can be detained under the Mental Health Act as well, but that's beyond the scope of this lecture. Now, the problem is that there aren't enough placements, there aren't enough places for children who need to be put into some kind of secure accommodation. And it's a very big deal if you do that. You can't just lock up people without having legal authority to do it. Now, this new section, which is in the bill, is designed to create a new form of accommodation to deprive children of their liberty. Now, it's going to be similar to secure accommodation, although looking at the new section, it will be different. But effectively, just to read it out, it says that the accommodation is provided for the purpose of the care and treatment of children and is capable of being used in whole or part in connection with the provision of such care and treatment for the purposes of depriving children of their liberty. Now, that's what the statute says, but there will also be regulations which are made. So if you're in secure accommodation, you're subject to you're subject to something called Section 25 of the Children Act, but you're also subject to something called the Secure Accommodation Regulations 1991, which set out how long they can lock you up for and when they have to review your case. This will work under Section 25, but it will have its own set of regulations. Now, of course, you can legislate, but then you've got to have the children's homes that actually can lock up children. Now, that means actual physical development. I mean, you know, there's a number of sort of children's homes, but they don't have facilities to actually lock children up. So whether this will actually lead to an increase in children's homes with secure, or being able to secure or deprive children of their liberty remains to be seen. But it's an attempt to try to increase those places, because at the moment, I mean, we only have in this country a few hundred places in England and Wales, just a few hundred places where we can actually lock children up, and there's never enough places, basically. Okay, let's have the next slide, please. Now, there's other amendments brought in. Now, another one is oversight of private providers of care and financial penalties. So that allows Ofsted, that regulates children's care, to issue fines to private providers. So this is all the sort of the feeling that, you know, private providers basically are profiteering. And so the idea behind this section is to say, well, this will give Ofsted powers to fine them, basically, and clamp down on what they're doing. And later on in the next slide, we'll see that they can also limit their profits. Again, I mean, I gave a lecture on this a year ago about private children's homes, and as I've said before, the problem is that there is a reason why children's homes are run almost exclusively by the private sector. Their profit margins are not actually that great. I think, you know, it's only about 20% profit. If you reduce their profit to zero, I mean, that has implications for whether they will be able to provide further care, as it would for any business. They're not all run by private companies. I mean, they're run by charities as well, not-for-profit organizations. But this is the government's reaction to the cost, and it's designed to try to drive down the cost. As I say, whether it works is another matter. I mean, the next one we've got here is agency social workers. So this is designed to stop local authorities from using too many agency social workers. So there's a chronic shortage of social workers, and the trouble is that where a local authority doesn't have enough social workers, it has to bring in agency people in order to do the work. And this is seen as a bad thing because, of course, if you're a temporary social worker and you're dealing with a number of children, well, those children will then see you come and go, which isn't good for them. So the government says, well, we're going to bring in new regulations to stop this from happening. But again, it's one of these measures which is going to come up against economic reality and the difficulty of recruiting social workers. So whether it works or not is another matter entirely. Another offence that is created by the bill is something called ill treatment and willful neglect of children of 16 and 17. So these are children typically in supported accommodation who are alleging ill treatment or willful neglect, and it's quite difficult to prosecute that. This creates an offence, ill treatment and willful neglect. So it might be fairly low level. It might be emotional abuse, basically, but it's an offence that can be prosecuted. I mean, the proof of the pudding in any statute that provides for a new criminal offence is how many people actually get convicted of the criminal offence. Because if no one's being convicted, it's not really working. So it'll take years before we see actually what the effect of this new legislation will be. Could I have the next slide, please? Now, the last thing that we'll say about the bill is that there are new corporate parenting responsibilities. And Section 21 introduces new corporate parenting responsibilities, which again you can see in the slides, and it's intended to beef up the existing duties that exist from a local authority to children in its area and young people in its area as well. The government says a new duty will create a culture change where government departments and public bodies actively consider how they can help to break down barriers to good outcomes. Well, this all sounds great, basically, but we shall see whether that actually works or not. Okay, next slide. Let's have a quick look at something called the Victims and Courts Bill. Now, this brings in a new section into the Children Act 1989, and it is designed for the situation where you have the parent of a child who is convicted of a serious offence against children in relation to a serious sexual offence. And they pop up in the county court and they say, sorry, not in the county court, in the family court, and they say, well, I want access to my child, and this has happened. And what this new section does is it says, well, it says to a Crown Court, you can actually stop that from happening. So if you're convicting this person for a serious sexual offence, you can also make an order that they can't actually have any contact with their child at all for a certain period of time. Okay, let's go on to the next slide, please, and look at the local connection test. So the local connection test, very briefly, is where you are in an area, in a local authority area, and you want housing, and you turn up and you ask for housing as a care leaver. The local authority says you've got no local connection. You were taken into care by the London Borough of whatever. You're now up here in the north of England, different local authority. You've got no local connection. We don't need to house you. Well, the government announced back in September 2024 that local authorities couldn't do that, and they brought in regulations in July 2025. And essentially, what it says is that you can't be penalised for not having a local connection, and that's because as a care leaver, you face unique challenges. Okay, next slide, please. The next slide is about care experience and protected characteristics. So there have been calls for care leavers or being a care leaver, being in care to be treated as a protected characteristic. What does that mean? Under the Equality Act, certain people have a protected characteristic, one being disabled people. And it means that if you have a protected characteristics, people have to make adjustments, employers have to make adjustments basically for you, subject to certain limitations. Now, they wanted to extend that to care experienced people, but the government said no. However, there are a number of local authorities already treating care experience as a protected characteristic and saying, well, that is something, it's similar to you being disabled, essentially. So that is something that is being pushed right now, and you can look at that in the notes. Next slide, please. The next slide is about the national audit on group-based child exploitation and abuse. Now, what is that? The government at the beginning of the year started getting very hot under the collar about dealing with child sexual exploitation. And of course, it's said that the only reason why they did that is because Elon Musk put out a tweet saying the UK government wasn't doing anything, etc., etc. Well, whatever the truth of that, all of a sudden they went into overdraft and decided to do something about it. So they commissioned a lady called Baroness Casey of Blackstock, who'd already been involved in one of the major child sexual exploitation cases, to publish a report on CSE, as it's called. And she came up with a number of conclusions in July, none of which will come as a surprise, but they're still important. She said that grooming gangs were often interconnected and they're based around existing social connections. Most victims are girls. And there are flaws in the way that data is collected. So there's no consistency between local authorities as to how data is collected on this difficult crime. Could we have the next slide, please? More efforts required to identify the nature of CSE. She talked about blindness, ignorance, prejudice, defensiveness, and even good but misdirected intentions that plays into the hands of the criminals. she said that the law should be changed. So adult men who groom or have sex with 13 to 15-year-olds receive mandatory charges of rape. So in the Sexual Offences Act, there's actually a separate offence for having a sex with a child over 13. So it is a crime, but it's not treated, or it may not be treated as serious as rape. And what Baroness Casey was saying, well, that should be treated as rape. It doesn't matter if there's any kind of element of consent or anything like that. It should just be treated as rape, which of course carries a very heavy sentence. Government hasn't taken that up for some reason. So there we are with that. And there's several police forces reopening cases of historic CSE. And in June 2025, the government indicated that it would fund a national inquiry into this issue. So that is where we are. Next slide, please. The government the government is going to create something called a new Child Protection Authority. So what is that? It's going to be a sort of national repository for England, and it's designed to provide national leadership and learning on child protection and safeguarding. So it's like a sort of national body that deals with the issue of child protection. It hasn't been created yet, but the intention is that it will be created. And then the final thing that we need to look at is the Online Safety Net 2023. So if we can have the next slide, please. So this Online Safety Act is an absolutely vast act, and it received what we call royal assent. So it sort of came into law last year, but what they do is they bring it into force by sections. And very briefly, what it does is it says to people who provide websites, you're under certain duties. If you're providing pornography, you've got to have age assessment. You've got to have that. You've got to have risk assessment as well. You've got to, monitor your websites so criminals can't use them to do harm to children, other vulnerable people. So you've got the act, and then you've got codes, and the codes go into literally hundreds of pages, and they tell internet service providers exactly what it is that they have to do. So we have something called the Illegal Harms Code that came into force in March 2025. And from that time, online services must protect their users from illegal and harmful content, including child sexual exploitation and abuse. And then we had something called the Protection of Children Codes. Now, they came into force in July 2025. And from that time, providers of internet services need to take safety measures set out in the codes of practice or use other effective measures to protect child users from content that is harmful to them. And that includes age checks, basically. And there is draft guidance on a safer life online for women and girls that was published in February 2025. So that'll be next, basically. And we think that the full act should be enforced by spring 2026. So again, interesting times to see how that pans out, because of course it's all regulated by Ofcom, and Ofcom have the power to fine, sanction people. They can remove websites if need be. I mean, they can even take action against websites which are not based in the United Kingdom. So we'll wait and see what action is taken and whether that act actually works in the way that it is intended to. If you read the Ofcom guidance, I mean, they are very positive about it, and they think it will work. But we shall see. Okay, that is the end of the seminar. And thank you very much for listening. The next seminar that I have, which you can find on Lime's website, will be on deprivation of liberty safeguards. So we'll be talking about that rather complex tangle and trying to sort of make sense of it, so you can understand it. But thank you very much indeed for listening, and I will close the seminar.